All right, welcome to the Chapter 9 video. I really like this chapter because it deals with some concepts that, frankly, these are the questions you get all the time when you tell people you're a CPA. So we'll deal with a continuation, really, of what we dealt with in really Chapter 6 and 7 when we talked about this continuum of expenditures from business to personal and how we deal with being able to deduct some of those items. And this chapter is chock-a-block with those types of issues. And it focuses on self-employed, but it does allow employee expenses to sneak in a little bit. And so we are going to spend quite a bit of time trying to classify someone who does work as either an employee or an independent contractor or non-employee, whatever you want to call that. And in the second half is deferred comp. And frankly, I just think they were running out of, where do we put this thing? Oh, let's stick it in this chapter. It doesn't really belong in here. There should probably be a chapter on retirement or investing or something like that. But it's just hanging out to dry in this chapter, so we'll deal with those issues as well. All right, well, let's get going. All right, so as I mentioned, oops, sorry, I got to get my little tag on it. I got to get my little thing out of the way. There we go. We need to talk about whether someone is an employee versus a non-employee or independent contractor or self-employed. And this makes a really big difference. And we'll talk about those differences. But there's three general categories that you consider under federal tax law to decide whether someone's an employee or an independent contractor. First is behavioral control. Right, so employees are directed and controlled by the business. So they receive extensive instructions, how, when, where to work, what equipment to use, what assistants to hire, where to purchase materials, etc., etc. They're under financial control, which is the right to direct or control the business part of the work. So, for example, no significant dollar investment, right? Employees don't make any investment in what's going on. The business makes an investment, and then they're just told what to do. Employees are reimbursed with expenses, right? Whereas an independent contractor may not be. And of course, an independent contractor has an opportunity for profit or loss, whereas an employee just gets paid wages. You can't lose, right? You can't incur a loss by being an employee. And then lastly, the relationship of the parties, which is kind of how do they treat each other, right? Employees receive employee benefits, for example, whereas an independent contractor would not. So those are the three main categories that you consider, but those are broken out into a large number of different factors. And I'm not going to read all these factors, but you should. So you may want to consider stopping the video and reading all these because, they just keep on going and keep on going and keep on going. And these are, the factors that the courts have said, hey, here's the things you need to consider when you're deciding whether someone's an employee or an independent contractor. So take the time to read those. And these are built up through a series of really federal court cases. Now, California has gone rogue, like it tends to from time to time, especially in the world of taxes. And they actually passed a bill. It's called AB 5. It was a few years ago. And it follows a test that was set down by a California court called the ABC test. So under the ABC test, a worker is considered an employee, not an independent contractor, unless the hiring entity can satisfy all three of the following conditions. So one, the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract for the performance of the work and in fact. So you can't just say in the contract, like, oh, they're not under my control, right? You got to look at the actual facts of the situation to make that determination. Number two, the worker performs work that is outside the usual course of the hiring entity's business. So that's a little bit like, well, look, the reason I had to bring in an independent contractor is this is not what we do, right? So we do not do our own tax returns. We don't have a tax department. So instead, we hire independent contractors to go do that work for us. Number 3, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So that means that this person that is doing the work normally does that kind of work as an independent trade, occupation, or business. So, those 3, that's a much more restrictive test to claim independent contractor status. The ABC test is quite tight. So, part A is the worker free from control. Let's go through what some of these items might mean with some examples. So, California Supreme Court in the Dynamex case, a worker who is subject either as a matter of contractual right or just in actual practice to the type and degree of control a business typically exercises over employees would therefore be considered an employee. So you're required to show up at 8 and leave at 5. Ooh, that sounds more like an employee, right? Depending on the nature of the work and overall arrangement between the parties, a business need not control the precise manner or details of the work in order to be found to have maintained the necessary control that an employer ordinarily possesses over its employees. So, just because they're not controlling the precise manner or details of the work, they don't have to, right? They can still exert control like an employee without digging in that deep. Part B. Does the worker perform work that is outside the usual course of the hiring entity's business? So this is prong B. So contracted workers who provide services in a role comparable to that of existing employees will likely be viewed, think of it as employees. So prong B is satisfied. Here's a couple good examples. Prong B is satisfied. Here's ones where it is satisfied, right? Meaning the services are not part of the hiring entity's usual course of business. When a retail store hires an outside plumber to repair a leak in a bathroom on its premises. Or when a retail store hires an outside electrician to install an electrical line. However, it would not be satisfied, meaning they are an employee, when a clothing manufacturer hires work-at-home seamstress to make dresses from cloth and patterns supplied by the company that will thereafter be sold by the company. Or a bakery hires cake decorators to work on a regular basis on its custom-designed cakes. Part C. Is the worker customarily engaged in independently established trade, occupation, or business? So the hiring entity must prove that the independent business operation is actually in existence at the time the work is performed, right? It can't start then, we're going to hire you as an independent contractor, therefore you're engaged in an independent business. Yeah, that's not going to get it done. The fact that the business operation could come into existence in the future is not sufficient. An individual who independently has made the decision to go into business generally takes the usual steps to establish and promote that independent business. So, do you have your own website? Do you have your own phone number, right? Have you established that you're a business? Do you have an employee ID? Think of them as being a number of different factors that you would go through if you were establishing or promoting your own business. Examples: incorporation, licensure, advertisements, routine offerings to provide services to other companies. It may not be satisfied where the hiring entity unilaterally assigns the worker the label independent contractor. So, it's been a long-standing argument even with the IRS that you don't get to choose whether you are an independent contractor or an employee. That's actually classified based on the facts and circumstances that exist. Where the hiring entity requires the worker as a condition of hiring to enter into a contract that designates the worker an independent contractor, again, same thing. That's not necessarily meaningful, right? The words you put on the page don't necessarily override the parts of the tests that they require us to look at. Okay, so I want to go over the old standard, and this is very much so like the old IRS test. This is the old California standard. And it was based on a court case called Borello. And it's a multiple factor case. And you can see factors aren't quite as extensive as they were in the IRS guidance that's been provided. They're only 13 as opposed to 20. But, you see a lot of the same overlap. So think of it as, for the most part, even California, which tends to be quirky, and the federal government would classify almost all employees the same way. Now, because AB 5 was subject to political negotiation, it means that there were certain occupations that either lobbied or fought or battled or whatever it might be, or it just made sense for them to be carved out. And so there are a number of occupations where the code basically wasn't changed. That's the way you need to think of it. And so Borello would still apply. And I'm not going to read all these, but you can see that licensed attorneys, architects, engineers, private investigators, and accountants are on that list. So there were some that you can use the Borello test, but you have to have met additional requirements first. I've provided some of those particular relationships here. Again, so think of these as exceptions to the ABC test, right? So you've got the ABC test, which we walked through, and then you've got Borello. And you say, oh, well, Borello doesn't apply anymore. Well, yeah, but it does. It applies to anything that gained an exception from the ABC test. Now, this class is not a law class, and employment law is a fairly sophisticated area of the law. But as tax professionals or as accountants, as CPAs, we certainly need to have some idea as to how this operates. Now, one of the unintended consequences, perhaps, of this is you could potentially have a worker that is classified as an employee for California purposes and an independent contractor for federal purposes. Now, I haven't looked. This would be a good question for our friend Jim, because I haven't looked under the hood recently, but I have a strong suspicion that if California classifies you as an employee and you're just going to follow suit, you're just going to do the same thing federally. You're going to have that person treated as an employee for federal purposes as well, as opposed to having them classified differently for one for Fed and one for state. Okay, let's stop there, and we'll put the next part in a separate video.